Good afternoon. I'm Julie Aldrich from the Office on Violence Against Women. I am the program specialist on the Justice for Families program, which we will be going through today and sharing information before the solicitation is posted later this year. The grants to support Justice for Families in the Justice System program, or is commonly known as Justice for Families, was reauthorized in the Violence Against Women Reauthorization Act of 2022, VAWA 22, to improve the response of the civil and criminal justice system to families with a history of domestic violence, dating violence, sexual assault, and stalking, or in some cases involving allegations of child sexual abuse. The program supports the following activities for improving the capacity of communities and courts to respond to families affected by the targeted crimes: court-based and court-related programs, supervised visitation and safe exchange by and between parents, training for people who work with families in the court system, civil legal services, and the provision of resources in juvenile court matters. A lot of times we get questions about who's eligible to apply. The eligible applicants, as the lead applicant, must either be a state, which includes territories, units of local government, which does not include law enforcement, courts, including juvenile courts, but does not include prosecutors' offices or attorney generals or other like offices, Indian tribal governments, nonprofit organizations with an active and valid 501c3, legal service providers, and victim service providers. The purpose areas covered in the Justice for Families solicitation are 6 out of the 8 available purpose areas. You'll notice that purpose areas 2 and 7 are related to policy implementation and are not part of the regular Justice for Families solicitation, but rather are implemented through technical assistance projects in the Office on Violence Against Women. The purpose areas that are covered in the solicitation are Purpose Area 1, Supervised Visitation and Safe Exchange; Purpose Area 3, Training for Court-Based and Court-Related Personnel; Purpose Area 4, Juvenile Court Resources; Purpose Area 5, Court-Based and Court-Related Based Programs and Services; Purpose Area 6, Civil Legal Assistance; and Purpose Area 8, Training within the Civil Legal System, Training within the Civil Justice System. Right. Purpose Area 1 is Supervised Visitation and Safe Exchange. This is to provide supervised visitation and safe exchange of children and youth by and between parents in situations involving domestic violence, dating violence, child sexual abuse, sexual assault, or stalking. Grantees providing supervised visitation and safe exchange services are not allowed to charge fees to parents served with OVW funds, because the funding should be paying for what you would normally charge fees to cover. Applications and grantees must align their programs with the OVW guiding principles of supervised visitation and safe exchange. The link is posted here, and the application should reflect the knowledge of those principles. Applicants also must describe safety and security measures with specific details, including adequate facilities, procedures, and personnel capable of preventing violence, and adequate standards where they are or will be, if you don't have a site selected yet, in place, including the layout, security features of the facility, and where in the community the facility is located. A lot of the precautions listed here can also be reflected from the guiding principles and should be included in an application. Applicants would also need to describe how they will develop protocols or policies to ensure that confidential information is not shared with courts, law enforcement agencies, or child welfare agencies unless necessary to ensure the safety of any child or adult using the services of a program funded by OVW. Again, a lot of the information that could be included in this as a response in the application can be found in the guiding principles. So a tip about the supervised visitation purpose area: referring and using the OVW guiding principles for supervised visitation and safe exchange is key to responding thoughtfully and fully to questions in the solicitation about safety and security and confidentiality. A lot of times in applications, we see other types of supervised visitation policies and procedures and different tips referenced. And while there are many great resources out there, the application for OVW must refer to these guiding principles as the basis of the supervised visitation policies and procedures. I have listed a few additional resources here. Many resources are specific to supervised visitation and safe exchange for families experiencing domestic violence and can be found through these two websites, housing a lot of literature about specifically supervised visitation and safe exchange for families experiencing domestic violence. This should not be a general supervised visitation and exchange response, including those that involve child welfare. It should be specific to those families, which would be by and between parents of families experiencing domestic violence. Purpose Area 5 is to enable courts or court-based or court-related programs to develop or enhance court infrastructure, such as specialized courts, consolidated courts, dockets, intake centers, or interpreter services, community-based initiatives within the court system, such as a court watch program, victim assistance, pro se victim assistance programs, or community-based supplementary services, offender management, monitoring, and accountability programs, safe and confidential information storage and information sharing databases within and between court systems, education and outreach programs to improve community access, including enhanced access for underserved populations, and other projects likely to improve court responses to domestic violence, dating violence, sexual assault, and stalking. The thing about Purpose Area 5 is it can be applied to on its own, but it does not need to include all subparts. You may include one subpart, or you may address more than one. Examples of activities that can be proposed under Purpose Area 5, since it is a very wide-ranging group of activities. Some examples are funding a domestic violence coordinator to enhance and process of handling domestic violence cases, create a dedicated or consolidated domestic violence docket, using funds to staff new positions in support of the docket, create an intake center in the court or in remote court sites in the community to process domestic violence protection orders and other court services. Funds can be used to pay staff, such as court staff or advocates, rent, or other related costs. Implement victim center opportunities, such as an expediter position, to screen for domestic violence and provide a voluntary and confidential process to help parents with orders of protection to develop safe and effective visitation plans and parenting time and address other child-related issues. Fund the translation of court documents, forms, and/or provide interpreting services for victims of domestic violence, sexual assault, dating violence, or stalking throughout the court process. Staff a court watch program, including court observers and data analysis of results. Conduct an offender accountability program. And here we have resources for abusive partner accountability programs and the guiding principles that have been developed under OVW. And more commonly, you may refer to these as batterer intervention programs. Enhance or create safe and confidential information storage and information sharing databases within and between court systems using funds for technology. And you could also conduct education and outreach programs about the court process for domestic violence, sexual assault, stalking, and dating violence cases, particularly to increase access for underserved populations. These are just a few examples. It is not limited to these activities. it is just focusing, this area has to be related to the court and court-based programs that benefit the court and enhancing the process of handling domestic violence cases. Another few additional resources for Purpose Area 5, civil protection orders. There's a complete OVW funded website about civil protection orders and how maybe you could use some funds to enhance your civil protection order process under the Justice for Families program. There's very good information about the domestic violence mentor course that OVW funds, and maybe there are ideas on those courts that you would want to implement in your own that Justice for Families funding could support. And also the improving family courts. If you are a family court or if you have a family court, you could use funds to implement some of the ideas that were demonstrated under a previous special initiative called the Family Court Enhancement Project. The Family Court Enhancement Project does talk a lot about the expediter position and what something like that could do and help identify families with domestic violence and help not quite mediation, but some kind of safe negotiations about parenting time can be done thoughtfully and safely. Purpose areas 3 and 8 are training. So there's a few differences that I like to point out about these trainings. Purpose area 3 is training for court-based and court-related personnel to educate court-based and court-related personnel and court-appointed personnel, such as custody evaluators and guardian ad litems and child protective service workers, on the dynamics of domestic violence, dating violence, sexual assault, and stalking, including information on perpetrator behavior, dating violence, sexual assault and stalking, evidence-based risk factors for domestic violence and dating violence homicide, and on issues relating to the needs of victims, including safety, security, privacy, and confidentiality, including cases in which victims proceeds pro se. An important thing to note when you're responding to training in the solicitation is that Purpose Area 3 does not include judges. Purpose Area 8 specifically points out judges and judicial personnel. For Purpose Area 8 is training within the civil justice system to improve training and education to assist judges, judicial personnel such as magistrates or other judicial related personnel, attorneys, child welfare personnel, and legal advocates in the civil justice system. When responding to the application and solicitation, it is important to note the differences between Purpose Area 3 and 8 to identify who your audience is. A few more notes about Purpose Areas 3 and 8. Training topics for either purpose area should be substantive on the dynamics of domestic violence, dating violence, sexual assault, and stalking, including information such as perpetrator behavior, evidence-based risk factors for domestic violence and dating violence homicide, and on issues relating to the needs of victims, including safety, security, privacy, and confidentiality, including in cases in which the victim proceeds per se. Training can also include topics such as firearms, language access, procedural fairness, civil protection orders, and any other related topics on the dynamics of domestic violence. The proposed activities can be a series of trainings, a newly developed curriculum, or other format, but it should not be ad hoc or sporadic, and there should be a clear training plan proposed. Proposed training should be specific, including who will be trained, the number of attendees, topics, and the purpose area for each training. Commitment to participating in the training should be included in your MOU or letter of commitment. Training proposed should not solely focus on the services of supervised visitation center to court personnel, court-related partners, and judges, but rather really a substantive topic. And that is usually one of the parts of the application that is a little weaker when we see applications, is that they're proposing supervised visitation and training, but they're only training on how the supervised visitation center is going to work. Training should really be more comprehensive, and it should also not just refer to outside agencies coming in to train or sending people to trainings. It should be a clear plan of who you're going to bring in if you're going to bring it outside, and not just funds for travel for people to attend trainings. Purpose Area 6 is Civil Legal Services. This purpose area is to provide civil legal assistance and advocacy services, including legal information and resources in cases in which the victim proceeds pro se to, in general, victims of domestic violence. And you can also provide civil legal assistance to non-offending parents in matters that, one, involve allegations of child sexual abuse, that also relate to family matters, including civil protection orders, custody, and divorce, and in which the other parent is represented by counsel. We get a question a lot about this, that, do you have to have A and B? It is A or B. You can serve victims of domestic violence, and you can also serve non-offending parents that meet those 3 criteria. Your proposed project in a response to a solicitation should not be a majority of the project for civil legal assistance, but rather it should be complementing activities to the project. If a project is mostly civil legal services, then it is more appropriate for the Legal Assistance for Victims, the LAV program, also an OVW program. And if it is heavily more than half civil legal services, it may not be considered for funding under the JFF program. Examples of providing legal services include provide an attorney for direct legal representation for victims of domestic violence, hire a legal advocate to provide advocacy for victims of domestic violence, create a legal clinic within the court to provide legal information and resources to pro se victims of domestic violence, and provide direct representation to non-offending parents in matters that involve allegations of child sexual abuse that relate to family matters, including civil protection orders, custody, and divorce, and in which the other parent is represented by counsel. The last purpose area I wanted to cover is Purpose Area 4, Juvenile Court Resources. This purpose area is to provide appropriate resources in juvenile court matters to respond to dating violence, domestic violence, sexual assault, including child sexual abuse, and stalking, and ensure necessary services dealing with the health and mental health of victims are available. Examples of this implementation in a proposal could be hiring a navigator for juvenile court to help provide options of resources, developing written materials for juvenile court explaining available resources, or hiring an advocate for juvenile court that assists victims of dating violence, domestic violence, sexual assault, and stalking. And this, of course, would be in line with your jurisdiction statutes. Choosing purpose areas. So a lot of times we get a lot of questions when solicitations are released about which purpose areas should be applied for and the combination. So there are some stipulations in our solicitation from year to year that apply. The Justice for Families is intended to be a coordinated approach to the activities described in the purpose areas. And otherwise, we don't want the work happening in silos. So that's a lot of the reasoning for a lot of these requirements. Typically, the JFF solicitation includes the option of applying for a standard or comprehensive project. These projects are not combined, you're not looked at together. So there's no benefit or disadvantage of applying to a standard or comprehensive project. So a standard project is applicants must propose activities under purpose area number 1, supervised visitation, or 5 courts. If you are proposing purpose area 1, supervised visitation, then you must include another purpose area. You cannot apply for just supervised visitation. And it also cannot just be training about supervised visitation to go along with it. If you are proposing purpose area 5, then you do not need to include any other purpose area. So if you are simply applying for a subpart of purpose area 5, you do not necessarily have to apply with any other purpose area. Comprehensive projects, applications must address activities under purpose area number 1, supervised visitation, 5, courts, and 6, civil legal services. Some common mistakes we see in proposed purpose areas. One is applicants misidentify their projects as a comprehensive when it is a standard project, including adding purpose areas that your application does not address in some of the other information. So if in your abstract or in your opening paragraphs, you reference that you're a comprehensive project, but you only ever address purpose area 1, supervised visitation, and 6, civil legal services, you will be at a disadvantage in this review of your application because reviewers will be looking for where you address purpose area 5. So being clear and concise about which type of project you are proposing will help reviewers review your application more thoroughly. Purpose area 3 or 8, training, are selected but not meaningfully addressed in the application or only focus on training about the supervised visitation center. This is one of the most common mistakes we see, is that the training purpose area is not well thought out. And that is one of the training is it sounds easy, but it actually is more thoughtful and more work than I think a lot of people think when they're first initially writing something. So there's very specific questions in our solicitation that address the aspects of training. Who will be trained? What are the topics of the training? It's okay to have a vague idea, but to be as specific as possible. Purpose area 5, courts, and 6, civil legal services, are proposed, but there is no clear difference in the activities proposed, and they're all related to civil legal services. This is one of the things where under purpose area 5B, there could be some civil legal assistance within the courts. What we don't want to see is that purpose area 5 and purpose area 6 are providing all pro se assistance and legal assistance, what would be categorized as civil legal advocacy. That is not an appropriate fit for the Justice for Families program. Again, that should be applied to under the Legal Assistance for Victims program if it fits in their purpose areas. Purpose area 5 should be focused on court activities and not necessarily civil legal assistance. Purpose area 5 is proposed, but the activities are not related to the court at all. We have seen this in the past where it may be loosely associated with the court, but applicants use purpose area 5 as a catch-all, but it really should be a very specific court or court-related activity. Under our solicitations each year, we have required partnerships. Applicants must partner with a court. This does not include a police department, a prosecutor's office, or a district attorney. It must be the court and the authorizing official to sign for a court, which is typically an executive officer or a judge or a court administrator. 2, a nonprofit, non-governmental, or tribal domestic violence or sexual assault victim service provider. Partnerships must be demonstrated in the MOU, the Memorandum of Understanding, and/or a letter of commitment. Common mistakes we see with these partnerships is that a district attorney's office or prosecutor's office acts as the court partner. While in your jurisdiction, they may be housed in the court, they are not considered a court partner by definition under the Justice for Families program. A governmental victim service provider is the partner. It is clearly must be a non-governmental, nonprofit, domestic violence or sexual assault service provider unless you're within a tribe. Partners are not included in the MOU or letter of commitment. Many times we see that the partners are identified within the application, but they are not included in the MOU or letter of commitment. The MOU or letter of commitment, applicants are generally required to submit an MOU, a document containing the terms of the partnership and the roles and responsibilities between 2 or more parties. However, courts that are precluded from signing onto an MOU may submit letters of commitment, LOCs, in lieu of an MOU. Note that LOCs submitted in lieu of an MOU under circumstances other than described in the solicitation will not be accepted or counted as a complete application. Common mistakes we see with the letter of commitment or MOU is that they are missing dates and signatures, completely. They must be signed and dated. Representatives who are not the authorized representative of an organization sign the MOU. The MOU must be signed and dated by the authorized representative of each proposed partner organization in the application. The letter of commitment does not include all the required elements detailed in the solicitation. That is a big one. A lot of times we see that the letter of commitment is more like a letter of support and is not responsive to the details that are specified in the solicitation. The MOU does not specify that partners have reviewed and approved the budget. And letters of commitment are submitted in lieu of an MOU, and the applicant is not a court. So being really careful and reading the solicitation carefully when it is posted about who's eligible to submit what. A lot of times in our applications, solicitations, you'll see that there is priority areas. So this slide talks a little bit about implementing OVW priority areas. The solicitation typically specifies OVW priority areas that are optional for applicants to respond to. If you do choose to address a priority area, you may be given additional consideration in your proposal. However, if you do not address a priority area, no points will be deducted for not addressing a priority area. We do not recommend that you address a priority area just to address it. It should be done meaningfully. And throughout the application, we're asked how to detail the priority area and how it will be implemented. It should be specific information. It should not be general. We want to include a couple general grant writing tips. We always recommend that you can begin planning your application prior to the release of the FY23 solicitation. Also, why we're doing these sessions this summer to help get a kickstart on that by using the FY22 solicitation and begin communicating with potential partners. It's never too early to start planning and thinking about whether you want to apply, even if the conversation ends up with the result that you are not going to apply. It is good to start the conversation so that when it does come time to maybe sign MOUs or letters of commitment, there's not a lot of questions. Read the solicitation carefully. Always good to read the prior year solicitation. In this case, our FY22 solicitation will be a really good help to guide you. Our solicitations, while there's minor changes each year, the general spirit of the program does not change, as it is part of VAWA and the statute. Using the checklist at the back of the solicitation to ensure you have completed all elements of the application is extremely important when you're about to submit the application. Review the MOU and letter of commitment requirements carefully and be responsive to all elements. Plan ahead to obtain MOU and letter of commitment signatures early in the application process. A one downfall we see is a lot of times nonprofit organizations are the lead applicant and they're underestimating how long it takes for a court to sign an MOU. Courts have levels and layers of approval and review, especially from maybe their own internal general counsels, and it really does take longer than I think a lot of people anticipate. Use headers in the solicitation in your application. Just responding to a solicitation is really a format. It is not a creative writing opportunity at times, and it really should be exactly responsive to the questions and follow the headers to be an organized application. And be responsive to all questions under a header. And if it is optional, it'll be specified. Navigating the application process. So a good thing to do, even if you're considering applying to any DOJ grants over the next fiscal year, as we round out DOJ's fiscal year ends September 30th. So as we go into the new funding cycle of solicitations, even if you're thinking about applying to any applications under DOJ, more specifically OVW, ensure your organization has a current SAM.gov registration, that is the System for Award Management, a UEI, which is a Unique Entity Identifier Number, previously known and was a DUNS number, is now a UEI, and you register with grants.gov. Ensuring these registrations are current prior to September 1st will help you with being able to apply for all DOJ grants. And you do not need to wait until a solicitation is posted to ensure these registrations are active and up to date and have contact people who are currently still working at your organization. All registrations are free. So even if you are considering applying to any DOJ grants, it is good to have active registrations starting September 1st. The application process is a two-step process. You'll begin in grants.gov for all DOJ solicitations and complete the application in a system called Just Grants. If you know you want to apply when a solicitation is announced, submitting your SF-424 and disclosure of lobbying activities in grants.gov early will allow you to begin the application process fully in Just Grants. Become familiar with Just Grants, even if you're just considering applying, by following the Just Grants link here and accessing the resources and training materials. We have a few additional resources and contacts here. You can always reach out for any questions about the Justice for Families program at ovw.jff@usdoj.gov. You can ask for Just Grants questions at ovw.justgrantsupport@usdoj.gov. You can always visit the OVW website, which is listed here, and you can sign up for notifications about Just Grants or about solicitations being released and other updates. And you can also access the grant writing tips PDF here. That'll give you a little bit more grant writing tips about responding to OVW solicitations. And so now we just wanted to go over a little overview of the program before we open up to questions. So you feel free to unmute yourself or put a question in the chat if you have any questions. Or you can raise your hand and I can unmute you as well. Yes, a copy of the slides will be emailed after this presentation as well as posted on our OVW website. And if you're having trouble unmuting yourself, please use the chat or the hand raising feature as well. The anticipated announcement date for FY22 awards, notifications have begun coming out. So you should receive something within the next week or two. And if you did apply to FY22, the solicitation, and you were not funded, please reach out to the OVW JFF email box to request consensus comments from your application, as those comments can help you reapply for FY23. And we really do encourage accessing those comments and using them to improve your application for future years. And even if you weren't funded in FY21 or 20 and you're interested in reapplying after a break, please, you can always reach out and get comments at any time for any previous applications that you have applied for under Justice for Families. So I see another question is, so we do a combination of DV supervised visitation and just custody related supervised visitation. Would you be a good candidate? So under the Justice for Families program, it sounds like you're asking, you do two different types of visitation. So if it was anything DV related, you could propose an application and you'd be a great candidate to propose to either expand that visitation that's DV related or to help assist and grow and strengthen that DV related. If it is custody or if it is child protective services, it's not by and between parents and does not have a DV component, then it is not eligible under this program. But we have a lot of programs under Justice for Families that do both types of visitation, and they're just asking for funds, and their application focuses around the DV visitation when they're applying to Justice for Families. Hopefully that answers your question. Please feel free to unmute if it does not, or use the chat. A list of past funded projects is on our website. And it is under the current funding and past funding. And if I can quickly pull up the OVW website, I can share that in the chat. Yes, every year we post all our website, all our previous and currently funded projects. So you'll always be able to find those applications. And trying to find that really quickly. Sometimes things get moved, so I'll try to put that in the chat, but also I will send that out with the slides after this as well. The anticipated award amounts for upcoming solicitation, we haven't changed the award amounts over the last several years. So it is up to $550,000 for standard projects and $650,000 for comprehensive projects. Another question was, we charge our local CYFD office, but would we still be able to qualify? I'm not sure what the CYFD office is. So if Jennifer, if you want to clarify what that is. And a funding period is always 36 months usually, unless otherwise changed. So we do request that applications do cover the 36-month time period. Another question is, are there any specific resources available for visitation programs that are funded in conjunction with child welfare? I'm not aware of any other specific resources, but usually when we have programs who do both, they just keep the child welfare piece a little bit separate, following those guidelines, and implement the DV resources under families that are by and between parents, not involving child welfare. But we have found that programs who use the guiding principles and in their other programming tend to be able to kind of identify when safety resources might be applicable during some of their child welfare cases as well. But in the PowerPoint, there's a lot of resources listed under those two links about supervised visitation and exchange, and you may find something more specific to what you are looking for in those. Jennifer, I see that you have clarified child protective services. So you charge your local child protective service office. Yes, as long as you're not charging the families that you are having under Justice for Families that are by and between parents of families that experience domestic violence, you can still qualify of applying and receiving a Justice for Families award. It's really keeping those two divisions of those programs separate. So it's keeping the child protective service piece and keeping that accounting lines all separate, and then keeping the families that you're funding under Justice for Families that are by and between parents that are families experiencing domestic violence, those you would not be able to charge fees for. I see, can a grant cover our building and security costs? Absolutely. If you're using your building for just the Justice for Families program, you would charge the full amount. If you're sharing it with other things, such as providing child protective service visits or providing civil legal assistance, you would prorate how much of the building you are using and security costs as well. So absolutely, those are totally fundable and allowable costs under this program. I see another question is, our current JFF grant expires October of 2023. When should we actively seek a grant to continue and enhance our work? That's a great question. So we always put in the solicitation, this would be your funding year to apply if you have less than 50% of your funds left. If you think that you would be able to request an extension and go another full year, we would not recommend you applying for funds during this next fiscal year. But if you are truly going to use the remaining of your funds to implement your project goals and objectives, and you'll be done by September 30th, 2023, then this would be the year to apply. We have another question. We have multiple franchise locations. Would funding be able to be used for all our locations or just one? That's an excellent question. I'm assuming we're talking about supervised visitation. So Sarah, correct me if I'm wrong, but absolutely. If you want, we have a lot of programs that do have multiple locations. There are requirements for each location. You'd have to submit a site plan and think about safety requirements for each location, but it's absolutely, we have some statewide projects that do cover more than one supervised visitation location. So absolutely, you can definitely propose to use multiple locations, just thinking about how the supervised visitation guiding principles impact each of those locations. So that's like the little caveat for that one. Any other questions? And in the chat, I'm putting the link for the awards, and they're done by each program and fiscal year and by state. And we'll also send it out to the group as well under an email with the presentation slides. Any other questions? You can unmute, you can write in the chat. We will definitely be posting this. This session next week will be identical to this one and will also be posted in case there's different questions. And we will be developing an FAQ based on these questions in order to post that as well, so everyone has access to it. And in case you don't remember an answer to one of these questions, we will be able to share that with everyone as well. We really do encourage that if this grant program looks interesting to you, if it looks like something you would apply to, that you definitely start thinking about it and thinking about who your partners are. We've noticed that the court is usually the hardest one to connect with and to sign on. And that should be for especially supervised visitation or civil legal assistance. Obviously, none of it's a court project. They're probably leading it, but it's really good to start getting those partners and getting the ideas of whether other people are interested in being a part of this project before the solicitation comes out. We expect the FY23 solicitation to come out sometime later this fall. So it is a good timing right now to start to get those partners and ideas and thinking about where your services would be, whether it's court services, a satellite office, or supervised visitation, or having services provided in a justice family center. It is a perfect time to really begin to get these ideas together and to start talking about whether you want to apply or not. And please continue to put questions in the chat. I will leave this open. If you don't have any more questions, feel free to hop off. All right, we have one more question. Do you have any templated letters or something to show the courts as an overview of the partnership? In our solicitation, there's usually a list of 11 items, 11 to 12 items that should be included in a letter of commitment. So we recommend that that letter be used, detailing each one of those things. You could honestly write a letter very similar to an MOU. It's just from the court only, and list out those numbers just like you would in an MOU to respond. Again, it doesn't have to be a creative writing exercise, but really be responsive to what we're asking. The clearer and more concise, the better. So you can really just follow in the solicitation what's listed there. You're welcome. If you don't feel comfortable asking questions in this forum, please feel free to email ovw.jff@usdoj.gov if you have a more specific question, or if you think of something after the fact, after you meet with partners. This is the time to ask questions if something's allowable, if something is a good idea, if something would be a fit under Justice for Families. This is a perfect time to do it before a solicitation is released. What is an MOU? An MOU is a memorandum of understanding. It's a document that's going to detail the history of your partnerships, what you've been doing for planning for the partnerships, and the development of the application. So if you look in our FY22 solicitation, it'll detail all of the details about what is needed in a solicitation and what you need to include in that MOU. And each partnership will sign on to that MOU. You're welcome. And I am putting in the chat the link for the FY22 solicitation as well, and we'll include it in the email to all participants today. And you can feel free to drop off if you don't have any more questions. Feel free to stay on if you do have a question.